Hunley has the whole monopoly. I don't know who that son of a bitch thinks he is.
Welcome to Laid Back Law with your favorite lawyers from around the interwebs.
No. Piers Morgan is doing the hide my boner lean. That's what he's doing. Look at him.
I think this is actually the first time that a billionaire cut safety standards, and it was the billionaire themselves that died.
And that's what made Poliere's, I don't even know how to pronounce this guy's name.
Poliere.
I'm board certified criminal trial law in Florida. I'm your man. Of course, you have to compensate me.
Discussing the most pressing of topics every Friday at noon Eastern Time.
I did this way before him. I had the big brain panel before Eric Hunley even existed.
All right. I heard a rumor there's a trial going on now.
Can you? I had no idea the trial was going on.
Well, I'm sure that Hannah Gutierrez would be happy that fewer people are watching. I don't know. Obviously, everybody's waiting for the headliner, Alec Baldwin, to come this summer. But Hannah's in trouble. I mean, it's not exactly a lightweight situation.
Well,
we were just
refresh everybody's memory. Hannah Gutierrez Reed is charged with what again?
Okay, Hannah Gutierrez, and this is the funny part because you could see the contention between the two sides. Her legal name is Hannah Gutierrez, apparently, or Hannah Marie Gutierrez. Her stepfather is Stel Reed. She picked up the Reed to get authenticity to her name as an armorer, but Bowles, her lawyer, will keep saying Hannah Reed, Gutierrez Reed. Carrie Morrissey makes it a point of saying, no, it's Gutierrez. So anyway, that's just one of the many, many squabbles and it's actually been in some of the court documents writing. Her name is such and such. She should be referred to as such and such. So there's some bad blood there. But essentially, Hannah was the armorer on the set of the Rust tragedy, October 21st, 2021, exactly one day before America's Untold Stories was rebuilt. And part of what we have covered in this time, we are finally in the first trial. We've already had one conviction with Dave Halls, who was the first AD. He pled out for a 6-month supervised probation or unsupervised probation.
So, hold on. Not a conviction. He agreed to a plea deal.
That's a conviction, right? I mean,
well, I just said.
Yeah, he was found guilty. He admitted to guilt. That's part of the deal. I'm guilty.
What did he plead guilty to?
Negligence, essentially.
Let me go pull this up. Okay.
Essentially, the negligent homicide or whatever.
Where have I been missing all of this?
Apparently, it's been winding up, and it's been going on for a couple days. Now, let's go over it a little bit. I know you were covering it yesterday, Danny, I believe.
Yep, and I'm covering it today, too, and we'll be covering it every day. My butt will be in this chair, and we will be watching every single minute of it. I am freaking eating this up because I don't have a dog in this fight. Frankly, I think everyone's messed up. I don't like the prosecutor. She's crazy cat lady. She's just intolerable to listen to. She's horrible. Do I think she's entirely politically motivated? Yeah. Do I think that she's targeting the right people in this case? In my personal opinion, no. I don't think Hannah was the only one. I think she should definitely be held accountable. But where's Sarah? Why was Sarah not charged? I don't see charges have been brought against her. Where's Gabrielle
Pickle? That's the big one, I feel.
Where's Gabrielle Pickle, who was literally where the buck stopped, who's not being brought in, not being charged, not being offered plea deals? She doesn't have to go through this rigmarole. So I don't like anybody. And frankly, I think that the defendant is kind of sick. And when I say that, I'm saying where there is, and this is just on my observations, whenever they show video of the quote unquote victims in this case, certainly victims of potentially an accident, a horrible accident that should have never happened. So when I say victims, not in the traditional criminal sense, but that's what this is. This is a criminal trial. In my opinion, this should have stayed in civil courts. However, where the criminal negligence comes in is with Gabrielle. They're just, maybe it should be a criminal trial, just the wrong defendant. Anyway, whenever they show the video of these quote unquote victims suffering, this Hannah has no reaction. She's sitting there picking her nose, kind of like, readjusting, just zero cares to give. But then when she sees her own video of her crying and she's like, I'm not okay, and having her alleged, meltdown and anxiety attack, all of a sudden she gets emotional. And I'm like, what the hell is wrong with you, woman? Like, at least pretend to care. So I don't have a dog in this fight, and it's just fun to enjoy at this point. It's a lot of fun to see the interesting lawyering techniques, the way that they approach this. I like the cross. So far, the cross examinations have been fire. So, in my opinion,
they've been decent. Okay, let's start with the opening statements, though, because I think the prosecution sucked.
Yeah,
that's just my personal opinion. I do not understand why the prosecution did not tell a story. I was like, tell me a story. Like, let me see. I'm not a lawyer. Let me see if I can figure this out. Okay. There's this lady, Helena Hutchins. She was born in Ukraine, came here to America to realize a dream. She got a degree and got to work on a movie set with an A-lister who was going to fulfill the greatest movie he ever did, his own version of Unforgiven. She was there filming that day. Everything's bright. She's got a new child, a young child, and a husband. Her future's going well. Until this fateful day where you have this armorer who didn't take their responsibility seriously, commingled rounds, and now she's dead. It doesn't seem like too tough of a story that would cover and obviously flesh out a little bit, but isn't that the case?
That was it. That was that. And they didn't even go into it very much. And what was, I posted on Twitter, and I stand by this. Their opening statement is proof that AI could probably do our jobs better. Honestly, if you had an AI voice and an AI presenter out there, they could have put together a better opening statement than the prosecution could have. And it's a really simple story. It's like you said, you start off with the victim. Here's the tragedy that happened to her, but this was a completely avoidable accident. And it just shows the negligence. It was criminal what they did to her. It was criminal that this had to happen. But it happened not because it had to, but because a bunch of people just didn't care. The person who cared the least, who had the most responsibility in this case, is the defendant, Hannah Gutierrez. She was not just tasked with this, she was hired to do this. People trusted her, people on set, people like the victim, and then point out her photo. I mean, it could have been easy. And they couldn't even do that. I don't know if it's a lack of coffee. Maybe the cocaine was all sniffed up by the defendant. I don't know what the problem was, but there was a problem with his delivery. It just bored us all to tears.
Did anybody? So I'm just now reading up as you discuss this that the Michael Hall, not Michael Hall, what's his name? Dave
Halls.
So he was convicted unsafe handling of a firearm, 6 months probation. Has anybody seen the statement of fact that he might have, or did he sign in that plea deal? Like, what was his unsafe handling of a firearm?
Well, he did not check the firearm before he handed it to Alec Baldwin.
And he's the one who
he only checked 3 rounds.
Cold gun and then gave it to her.
Correct.
Okay,
and
now
so
Hannah Gutierrez is on trial for involuntary manslaughter.
As well as Alec Baldwin.
If you got one strike in a deal, Hannah, if she gets convicted, but then it's going up in the chain of responsibility because Baldwin's the one who pulled the trigger. Do we know how the live rounds got on the set yet?
Okay, but that's the argument, and that's what Bowles is flailing about because he wants to blame Seth Kinney. What you have going is a trial where the prosecution's going after Hannah Gutierrez Reed. Jason Bowles is saying Seth Kinney and his sidekick Sarah Zachary were the evil manipulators who had a phone call and hid everything. But it came from them, really, them. It was sabotage. I say it. It was sabotage. Anyway, that's essentially the Bowles defense. And if you look at the pre-hearing, et cetera, it's going down that path. And it's frustrating for me. I can't talk to Seth right now for obvious reasons. But
Seth Kinney was not charged with anything, correct?
No, he was not charged with anything. He was actually sued. And this is where it gets really interesting. He's such a bad guy that Hannah Reed sued Seth Kinney civilly only to have that dismissed with prejudice by their request. Very interesting. So if Seth really is the bad guy, really did why did they drop this? Why did they drop the lawsuit?
It's fun,
makes
right?
you wonder.
This is such a fun case. Honestly, I came into this thinking this is going to bore me. I'm not interested. No, this is actually become a really interesting case just based on the absences, right? Like, there's so many holes in this case. Where are the charges against Seth? Honestly, if you're right, let's say that he had nothing to do with this to the degree that they would just settle. I don't know the terms of their settlement. I don't know all that was involved in the civil lawsuit. But it is fascinating to me that criminal liability didn't attach to him, because we're looking at the prop house right now and we're looking at these boxes. Nothing is secure. Nothing is secure right now from what's being shown, from what the defense is showing. So the question is if it's messy at the supplier level, how was Hannah Gutierrez supposed to be able to distinguish all of these how is she supposed to do her job? That's the question. She's not only being told to do her job, she's being told not to do her job. If you look at the OSHA report, which are they allowing it in? I don't recall.
They're allowing that in, and actually, we broke the story about that email. That's one of the things that I had between Gabrielle Pickle and Hannah Gutierrez.
And it's devastating. I think it is. If you have people telling a 24-year-old employee, no, you're contracted and your contract tells you to do this, but I'm telling you not to do that. I'm telling you to go do these other things. Sure. Could she have walked? Absolutely. Would she have been blackballed by all of Hollywood thereafter? Would she have been badmouthed by Alec Baldwin? She doesn't know that. Would Gabrielle would have gone out of her way to make sure she never gets another job if she had walked off the set? Probably.
Yeah, well, I don't know. It's a hard call. And one question, though, the PDQ pictures, if I recall, that was from the search warrant on November 30th, correct?
I believe so.
Okay, well, but because this is a significant factor,
so.
It was after all these things went awry and there were the problems, etc. And if I recall, November 30th is when he just wrapped Las Cruces with Bruce Willis and came back in and dumped. Well, I'm just saying, come back to the office, dump everything in. When they say unsecure, whatever, there are different stages. Now, I'm not trying to make an excuse for him. I'm just saying that when the pictures are taken is very interesting as well, because he's painting a picture, and Bowles has been doing this for a while. He's been trying to say Seth brought the live ammo. Seth brought the live ammo. It came from Thel. Well, they never found any live ammo that was tied together. And if you look at the police, right, they have not, actually made those ties. They also tried to say that he had a defective gun. Well, he did, provide the proof and the receipt that it came straight from the manufacturer to the set. It was a brand new gun. So.
I think where criminal liability lands squarely is on the heads and shoulders of all the producers, co-producers, directors, everyone who's on set.
There you go. Joel Sousa.
Happening to the degree that people were walking. People were walking. You had actors, set designers, people who were there who said, F this shit, I'm out. I'm not doing this anymore. I'm not going to get killed. You guys are playing games. There's been 2 misfires already, and you're not calling a halt to production to address these problems.
Yeah, that was Lane
Hannah
Looper.
Gutierrez raised the issue. They didn't, put anything on hold. So I don't know. It's fun. I'm enjoying this case.
Well, and that's a big question. Because Joel Sousa got shot himself, I feel like he's escaped a lot of blame. Keep in mind, he is the director. That is his set. And if you look at Randall Miller, I don't know if you've ever read about the Georgia case with the train, but the director, Randall Miller, went to prison as well.
Is this the case where they got ran over a while back?
In the train, yeah.
A
PA got ran over in Georgia. Yeah. It was a movie about Greg Allman or Dwayne Allman. But anyway, I'm just saying, Joel Sousa's kind of managed to skirt through. So I do agree with you. Gabrielle Pickle, there are questions there. Probably should be some charges. Joel Sousa, absolutely. I don't want to say that Hannah's off the hook either, though, because Hannah sure has responsibility in this mix too. And a lot of people are saying, that she was charged instead of Alec Baldwin. So no, they both got charged.
Yep.
It was in addition to.
Yeah, I'm in a very judgy mood from start of this trial till now. You go to jail, you go to jail, you go to jail. Everybody needs to go to jail, honestly. Like, this really was criminal negligence. If we're going to say it was criminal negligence, then it needs to fall on the shoulders of those who had authority, those who were making calls, who were calling the shots and saying, yeah, literally calling the shots in in film terminology. They were the ones who were saying, angle it this way, come over here. They were the ones who were in charge of the entire production set. They were the ones who had that 20,000-foot view, and they failed to press pause and say, we need to implement safety measures here.
I suspect everyone in the chat already knows, but Hannah Gutierrez was not in the church at the time of the shooting, so the accusations or the factual basis for her manslaughter is having mishandled live rounds?
Well, she loaded the shot that caused the fatality. She loaded that gun. That was her. And the prosecution's claim is that she brought the ammo on the set. She commingled it. The defense is, no, she didn't. No. It was Seth Ken. Except Seth wasn't on the set. Well, so this is a confusing part because technically speaking, they want to go Seth and Sarah Zachary, because Sarah Zachary worked for PDQ and she was the prop master, so in charge of the department. Hannah worked for her technically on the set. Seth was the supplier, so he ordered the gun, he ordered the ammo, whatever else it was. It's kind of it's tricky for them on the defense though, because how did Seth get it to the set? He didn't take it. So it has to be somebody else that did it, or Hannah had to completely unobserve that Seth had somehow mixed the rounds in together, and then she took them and didn't notice them.
Did they account for the plinking on the set yet, or was that addressed?
Nobody's ever proven that. We'll see if the prosecution brings it up, but I noticed that it didn't come up in the opening statement, so I have a feeling, as annoying as that guy was, so detail-oriented versus story-oriented, that they're not going to say it. So it's going to be a tough one.
Well, so Baldwin's going to go to trial after this. Looks like by the summer. Hannah, we'll see if she gets acquitted. One way or the other, acquitted is no better an indication for Alec, but found guilty or convicted, that'll be a very, very bad sign for Alec Baldwin.
Well, not necessarily, because then Alec goes in and he says, "You've got them." Dave Halls and her. What do you want? They had one job, and that was to give me a safe gun, and they didn't do it. So tough. I'm just saying. He's
the co-producer. That's the thing. He's the co-producer. He's the guy who should have said, when he knew about everything that was going on, this is why I say the people in authority, the people who are calling the shots, should have been the ones to be charged. This was the correct charging, because he was the one in charge of all of this. He was the one who aimed. He was the one who fired. He was the one who was negligent in checking his own gun like he was trained to do with Gutierrez. And that email only goes further to the point, whether it's true or not that she was actually training Alec Baldwin is another discussion, and she wasn't just putting in hours. But regardless, he has extensive training. He's made public statements to that effect. He knew better. He failed on multiple levels.
His father was the coach of the rifle team.
Well, the guy who pulled the trigger.
Eric, you make a good point that he gets to scapegoat Hannah, but he also made the statement in that interview that you never point at a person, that you don't pull the trigger, that he didn't pull the trigger. Now it's going to be, I don't know what happens to the defense that she put the live rounds in, but I still never pulled the trigger.
Again, though, David, as long as he doesn't testify, because that would be the killer, is if he gets on the stand. He doesn't have the temper for it. His lawyers can shred a lot of the other people, and there's a lot going for him in the sense of the police investigation. They've admitted multiple mistakes. The Lieutenant Benedictus or whatever admitted, he sent somebody to go pick up the cart instead of doing it himself. That's a bad move. And then he was saying, "Oh, I was watching the whole time." I'm like, it's 50 yards. How are you going to do that? Can you tell? I work with Spidey Bedros. He's a magician. Okay, they'll do it in front of your face. So 50 yards, you send somebody to get a cart, which you should be retrieving, and you're saying you're watching them when you're watching two other people. unlikely. That didn't go well. They also showed on his body cam somebody reaching over the evidence tape, picking up a dummy round and shaking it, and then putting it right back down in front of 2 cops who let him do it. And these are all really bad looks for the prosecution, I think, because it was chaotic. And that's the part I think that helps Hannah, and Jason Bowles needs to milk as hard as he can, is it was chaotic. It was chaotic. It was chaotic. But the weird thing is I still don't understand why they have not brought up the fact of the COVID protocols, because the COVID protocols to me are a very significant factor in the fact that Hannah was not allowed inside of the church because she wasn't deemed necessary with the rings of the COVID protocols. And that right there, I don't know. It's just like systemically, you prevented her from being able to do her job with
Eric,
these protocols.
It's just another COVID death.
That kind of is.
All. It's just another COVID death. Nobody cares. But you're absolutely right. They not only prevented her from doing her job with COVID protocols, they prevented her from doing her job by assigning her other jobs, by not paying her and saying you're limited to 8 days and you have now exceeded the scope of your contract. And if you do any armory work during the time that you aren't within those 8 days, we're not going to pay you as an armorer. We'll pay you for your other position, which is insane. It's insane. So
have we looked into whether or not Helena was a Trump supporter?
I don't think so.
Oh, okay.
But,
I had one question. Has there been a question about the chain of custody? Hannah not allowed into the church because of the COVID rules, so who knows what happened to the firearm?
There has not been, but that's always been the problem with Dave Halls. He handed the gun to Alec Baldwin, and he should not have been handling it, period. And it's a weird bylines, but the first AD is considered in charge of safety on the set. So his job is not to handle the gun. His job is to look at it and tell Hannah, show me.
But Hannah's not there at the time that exchange of hands occurs.
But this is where it gets confusing, because go watch Alec Baldwin's testimony inside the police station on day 1 when they say, who gave you the gun? Hannah. Hannah gave you the gun. Yes, always Hannah. So on that day, he said it was Hannah that gave it to him before lunch and after lunch. Then later on, he changed to say that Dave Halls said cold gun. So it's always been a little bit muddy, and I've always found that to be a sticking point, that why was Dave Halls handling the gun at all? Technically, that should have been Hannah right there. Like here, if he had to hand it off to her, she would handle it and then give it back to him, whatever. If they're doing like a rehearsing, or he had to put the gun belt on or what have you, or change wardrobe, that would be her job, but she wasn't.
Well, Chugi Show Live says her being in the church doesn't negate the fact that she put a live round in the freaking gun. It causes a question as to chain of command and whether or not someone else handled the gun in between. If she had to give it to somebody, slide it into the church, and she's outside, who the hell knows what happens to the gun before it gets into Alec's hand?
So was it her job on that day? That's the other question. If there was confusion about what her contract said and when she's the armorer and when she's not the armorer, how is she supposed to know, or anyone else for that matter on set, who's supposed to be handing off the gun to who on which days? I mean, this is why I say this is a production issue. The production should have lined up all of their scenes dealing with live round or with ammunition and gun sets and gun scenes to align with the armorer days. They failed to do that. That was the whole idea. It's a cost-saving measure, and they effed up.
Well, and the camera crew walk. This is why it's such a crazy situation. The camera crew walked off. Now, people like to say, oh, they had safety issues, that's why they walked off. That's technically not completely the case. There was a dispute between Gabrielle Pickle and her crowd and the camera crew, because Gabrielle Pickle and their crowd had hotel rooms that were local in Santa Fe. They had the other ones staying almost an hour away in Albuquerque, which pissed them off because it was an hour and keep in mind, the first people on the set are the people setting up lights and cameras, right? And people tearing it down. So we're talking a 14-hour day, suddenly a 16-hour day, 17, whatever. And they were saying, we're having to sleep in our cars. This dispute took it to another level when Gabrielle Pickle and them made T-shirts saying that they were locals, or I forgot the T-shirt, but it was like just a shitty move where they had T-shirts essentially saying that they got the cool hotels and rubbing it in the camera crew's face. That's when Lane Looper went to Alec Baldwin and said, this is screwed up, blah, 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 blah. And then he walked in the morning. His walking in the morning is what led to Helena Hutchins being inside of the church filming the shot because they were waiting for the new camera crew to come in, replace everything. They had Video Village, but the Video Village operator was gone as well. So it's just like a confluence of crazy events that caused this to take place. Now, Lane Looper, I feel, is even more personally motivated to go after everybody because if the Video Village was available, Lane Looper would have been the one in the church next to the camera. His job is the focus puller. So he would be focusing the camera, et cetera. So ironically, if he hadn't have walked and the incident went down, he might have been the one who got shot. And a lot of people don't realize that.
I see. I also saw Chuy's comment, and I think your response, Viva, is actually a great example as to where, at least to me, and this really is not. You don't need to be a lawyer to try and find this distinction. Where we talk about the difference between likely to happen, what's more likely than not, versus reasonable doubt. So, as the armorer, and do I think that she's likely the person who ended up putting that live shell in there? Yeah.
No, she is.
But
she said it.
She's
admitted it.
She's admitted she put it in there?
Yes.
The live shell or loaded the gun?
She loaded it.
Well, that's different than knowing.
Yeah, but the question is,
but she said that she put it in there. As a matter of fact, she couldn't fit it in because she hadn't been cleaning the gun and had to scrub it out to get the round to go in. This is in her police questioning.
No. Well, she said she did that. Is that confirmed that was the live round? Because having loaded the gun, as she admits to, yes, but not loaded with a live round. I mean,
I just want, if I can just finish my point for a moment.
No, not yet, Joe. I'm sorry, I'm joking.
Everybody interrupt Joe.
Assuming that's to me the difference between preponderance of evidence standard and reasonable doubt. Because do we all think that she probably did it? Yeah. That she probably is the one who put the live shell in there? Yeah. But is it really an unreasonable doubt to say perhaps the guy who handled it after her put it in there, even though it's unlikely? To me, I think that's a reasonable suspicion, which is why, to me, that could create reason. That's in the chain of command and the chain of custody there. Mm-hmm. Definitely, you can make a strong argument to a jury that's not reasonable doubt, beyond reasonable doubt anymore. That might be, you might think that's what happened, but as far as beyond reasonable doubt, that someone could have put a bullet in there. I think that seems to be really, that seems to be in jeopardy trying to say it's beyond reasonable doubt.
I agree with Joe. Okay, love you guys. Bye.
See you later.
Bye.
And symmetry. Oh.
That makes him happy.
Sexist.
I think she's back covering the trial.
Yeah.
Most likely. So, okay. So are we done with this for the moment?
Yes.
Okay. Let's
get
talk
to
about
Fannie Willis, people. Nobody's following Fannie Willis?
Oh, I am.
Dude, there's some
I'm following,
good info coming out today.
I'm following Fannie like a dog who just is just marching after it. Just sees Fannie and it's like, oh, that's where I'm going.
Well, so the news of the day in a court filing is that the Trump team has now obtained AT&T records showing that Nathan Wade was at Fannie Willis's yurty apartment, visiting far more often than he said during his testimony, arriving at midnight and leaving at 4:55 in the morning. You didn't hear this?
No!
I made a joke on Megan Kelly tweeted out the other guy who tweeted, and I was like, man, he went from midnight to 4. I would have been out of there by 1 o'clock. Well, it was actually 12:45. Dude, I was like, forget disqualification now. What's going to be the penalty for perjury?
Because, yeah.
It's wild. No, but it's so
for both of them.
For both of them. I mean, first
They
of all,
really could. They could really see the license to suspend her. At this part,
it's wild. Yeah, I have to
The
go.
perjury is tough. Yeah, the perjury is tough.
This
Nate,
they're out of this case. I'll tell you right now, they're out of this. If they
that's
have
my
phone
I
records-
don't know. I don't know. There's this judge, because don't forget, even if the relationship stuff is true, you still have the disqualification is really about whether she was getting a kickback. Which I just to be clear, I totally believe she was getting a kickback.
Here's
But
the thing.
if the whole disqualification piece is whether those gifts and stuff, whether she reimbursed them for those gifts and stuff, because that's the key piece of this.
Yeah, but let me ask you this: as far as the yardstick here is not beyond a reasonable doubt or even it's a preponderance of evidence. It's like the appearance of impropriety is the problem. And if they are so desperate to cover up their relationship that they would perjure themselves on the stand and in affidavits as to when this thing happened, that has to lead you. And you also have, and also they have no documentation that she gave him back the money, right? I mean, it's all this.
Joe, she said it, so it's a fact.
Right.
I testified.
All of this, and you're willing to lie under oath in front of God and this court and basically say that this relationship only started in March of 2022, and you have phone records that.
And then Joe, not to interrupt you, but even then, they were involved in a relationship when she renewed the contract and increased his hours. So even then, there's impropriety.
Although you could say, I agree with you on that. I agree with you on that, but once he's in already as a special prosecutor, to say that someone else should pick up the ball because they're in a relationship.
No,
now,
but you renegotiate and increase his hours. I mean, there's while you're vacationing with him. I mean, it's
that. Don't get me wrong. It's all craziness, but I think again, if we're just talking about, because disqualification is really tough, guys. I'm just gonna call it's a very high bar. So I do understand. Like for me personally, I would disqualify them. I would be like, this is just enough. I don't believe her. But just so we can break down everything, the perjury, which I do think it's perjury if what you guys are saying is true, that goes to the credibility of the witness. So I think the ball rolls this way. She said the relationship started in 2020, but they said the relationship started in 2022. They have two witnesses that now conflate that say, no, the relationship started back in 2019. If that's true, that goes to their credibility on the issue of whether she was getting a kickback, because the only proof they have that she wasn't getting a kickback, like Fannie Willis said, is my good name. So now you can add that to say whether if there are issues about credibility or whether she was paying back in cash, can the judge believe that? And I think right now, if what you guys are saying is true, then that destroys their credibility and then leads to the appearance of impropriety of her getting a kickback. So I think that's the train that the defense is trying to go.
I heard, did she declare plead the fifth on the stand?
No.
Oh, no. She did the exact opposite. I think she screamed.
I saw it last week, but I didn't know she got called back up.
Yeah.
No. So what? She finished testifying on Thursday, and it went so well that even though her lawyer said they had 4 or 5 more hours with her the next day, she didn't come back or enter the courtroom.
Yeah, she did. But she did. I don't think she needed to do cross-examination, because the cross-examination is just giving the story, and it gives the defense another bite at the apple too. So I think that was a smart move. If it was me, I would tell her, "Why am I going to cross you? You did fine by yourself." She didn't give enough to disqualify, but I do think she should be disqualified. I think but this judge gave her money. He used to be an ADA under her. It's going to be tough.
Well, I talked about that. It was $150. I mean, but in 2020, before he's a judge, maybe he actually thought she'd be good at her job. Who knows? Also, I think
maybe they're friends.
No, but the maximum donation is in the thousands, so it's a piddly amount. But he worked under her, and he didn't mention that or disclose that to the parties. It's the failure to disclose the insignificant or non-material facts that's more interesting.
Isn't it hard though in that area if they're all interconnected?
Yeah, you don't have to disclose that. Okay, I've been like my boss was a judge, and then he moved over to be my. It happens a lot. A lot of the judges, a lot of people don't know this, are generally ADAs that just get moved up. So that's just the way it goes. Like when I was at the Bronx DA's office, all the 90% of the judges I was in front of worked in my office before. They worked under the DA, and the DA was there. His name was Robert Jones. He was there for like 40 years. So it just happens. It's just the nature of the beast in criminal law.
I'm going to push back on you, Nate, a little bit here, where you're basically saying that it only affects credibility, because it doesn't simply reflect credibility of the fact that they wanted to perjure themselves, which it's not just a mild impact on credibility. It basically is saying you can't believe anything they're saying because they showed that they have a willingness to lie in the stand. So how do you believe anything that's not documented? Because they basically say we are so vested here that we are willing to perjure ourselves as a freaking district attorney and get up here on the stand and lie about when things are happening. That's an insane thing. But it's more, to me, it's more than just a credibility issue. To me, it's a matter of they're showing that level of vestment. That is what reeks of the fact that there is actual impropriety here, or at the very least impropriety standing on his face. Even if we didn't know anything about the money, that would say to me, why the hell are you so, why wouldn't you just tell the truth? Why wouldn't you just tell the truth if they were, and just say, yeah, we did a relationship, but like, you know, we went all the way back to a year before he was hired. And that makes sense why, if you think about it, one of the things that came up on the stand was when Roy Barnes got on the stand, he's saying Nathan Wade was at that meeting when he was being asked.
Kind of undermines
That's the weirdest thing. He wasn't working for the district attorney's office. What the hell is he doing in that meeting? I mean, it's a meeting between the district attorney's office and a potential special prosecutor, and he's there. If he's not there as some attorney boyfriend, what the hell is he doing there?
Well, he was there. Well, just to be clear, it wasn't just one special counsel. There were, I think, 3 or 4 hired, and I think he was going to be part of the team. But then you wanted to have a lead, so they were interviewing for the lead, and he was on the team. That's why he was there.
That's great. That's a very solid answer. I appreciate that.
But I was going to say something about the perjury and whether or not it only goes to credibility. It'll give the judge the justification and the public argument support to disqualify her. So even if you were on the fence, this is going to say they're perjurers. I don't believe them, and now I have the political cover to make what would have otherwise been a politically unpopular decision.
Don't forget though, this is hell of a messy. Because don't forget, to prove the perjury, essentially, what you're going to have to do is kind of get through that attorney-client privilege, because that's really what we're talking about here, right? The person who even brought all this stuff up happens to be Nathan Wade's attorney, who was representing him in the divorce, and says he got all this information we're talking about from his client in furtherance of legal advice. So if that's the case, so that's where all this stuff is coming from. So I think you have the fruit of the poisonous tree scenario going on here, where just so everybody understands the background, Nathan Wade's attorney, his former divorce attorney, is the one who sent all this information to Trump's team. Trump's team then filed this motion to disqualify. So now Nathan Wade is saying, well, hold on. If the whole thing is based on attorney-client privilege, then this should be thrown out anyway, because they wouldn't even know about all this, unless my lawyer broke confidence and gave up my
nothing of what that lawyer knows is protected by solicitor-client privilege. None of it. The judge is going to get it in camera.
But if you're talking to me, if you're in a divorce and you tell I was sleeping with this woman all this time, you're telling me that's not covered in a divorce under attorney-client privilege? If you're telling your attorney,
I'm telling you that of
course that's covered.
I'm telling you that when he shows up to her and says, Terrence, I just got back from Big Fanny's house at 4 a.m. We were doing it all night long. That was not
that's not attorney-client. That may not be attorney-client. But the fact of the matter, if I'm your attorney and you tell me you're cheating on your wife and we're in a divorce, of course it's going to be. But now that's what the judge got to do, the in-camera review. Was this in a bar over a beer? Or was this in an office, or was this during what we were doing? So that's where I think it is. But I do think the legal issue of attorney-client privilege is still a live issue. But they'll answer that today.
Okay, so I have a lot of pushback on that.
Go ahead.
And here's why. First of all, the motion I think that Wade filed is a tell as to how terrified he is about Bradley knowing information which will reveal that he perjured himself and potentially subject him not merely to disqualification from this case, but disqualification from the bar itself. And I think he's terrified about that. I think Fanny's terrified about that. I think the legal arguments were thoroughly illogical, like stupid. They were like stupid arguments. They were like, well, you're ready. The root of their motion, where they're trying to say that the judge is not allowed to even hold an in-camera review with Bradley, is, well, you already ruled on this. And the judge knows that the reason he ruled on it is because this guy kept saying, well, this is privilege, this is privilege, this is privileged. And then later on, like 2 hours later, he makes it clear that he says privilege even when there is no privilege.
Yeah.
So he's completely unreliable. And that's the entire argument. I mean, I think it's a joke. But what I want to point out as far as like the communications that are privileged, and you want to say that everything that he says, which he claims it started in 2015, which is very difficult to believe, that anytime he would mention Fannie Willis between 2015 and when his representation ends is now privileged. Because,
no, I did not say that. I just want to make very, very clear. That is not my position. That's a mischaracterization of my position.
I'm not trying to mischaracterize it.
All right, it depends on the facts and circumstances in which the communications happen. That's why earlier I said in a bar over a beer or in an office, in legal advice. So that is not my position.
Okay, I understand that, and I agree with that part of it. But I just want to point out that these two individuals specifically had to have had many hundreds of conversations invoking the very name Fannie Willis, which are definitely not privileged communications. For example, this guy was hired by Fannie Willis Bradley was hired by Fannie Willis to do a taint review. And that came courtesy of a recommendation from Wade, which that itself is is a little bit sus. Like, why are you hiring his? Let me just finish this up, Viva. So why you're hiring this? But what must have happened is that he must have gone to Bradley and say, hey, I had a whole conversation with Fannie and she's going to be calling you about potentially being hired for this taint thing. He's talking about Fannie all the time with Bradley in contexts that are certainly not privileged. So, when he was asserting privilege, the implication was anytime he mentions Fannie, that must be privileged, and that's what you were making that implication.
They were
that
making
was the implication that his counsel was making throughout the hearing, and it's clearly not true as a matter of law. And then Bradley displayed he doesn't understand where privilege attaches, and he doesn't know
he understands where it attaches.
No, but Joe's on fire. He's right.
Or that he's at the very least willing to claim that there's an attachment of privilege when there certainly is none. So now there's no way, and that's what made the judge say, I need to have an in-camera review with him, and that's why this motion, I'm telling you now, this motion that was filed by Wade is going to fail. They are going to have that in-camera review. Frankly, I thought they were having that in-camera review last Friday.
Last week.
Yeah, it was very weird that they're bringing a motion now for that, but obviously there's further in-camera review, and that further in-camera review is clearly terrifying Wade, and I think that he knows he's going to be subject to sanctions from the bar as a result of this review. We're very, very afraid that that's likely to happen.
The question I had is
trying to get in.
No, it's actually not related to the Fannie Willis, but signing a taint review with her boyfriend's external firm, like it was with Wade's firm, Wade, Campbell, whatever it was at the time. How the hell is that even permissible?
Yeah,
set aside Trump, whoever else was convicted under Fannie, while she contracted out to her boyfriend's firm taint review so that they decide what to share and what not to share with the prosecutor, that being the woman that's boning the guy from the firm. How is that not a fundamental problem in other cases?
I don't know, because relationships happen. It's a tough, because again, the salaciousness about the relationship is relevant, but it's not the disqualifying factor. But I do want to say one thing. Joe is number one. Joe keeps saying I'm pushing back on Nate, but then he validates my whole point. Joe, exactly what you said is correct. I agree with everything you said. There was no pushback there. But I think we all need to understand how this developed, though. Don't forget, and Joe, I watched part of it with you. The attorney, Terrence Bradley, didn't initially say this was attorney-client privilege. He initially asked for Rule 1.6 to be invoked. Now, 1.6 is a rule of confidentiality. That means, so if you come to me and I'm not your attorney and want to get legal advice on a pending case, hey, listen, I have this case, I want you to evaluate that. That falls under Rule 1.6. 1.6 is the rule of confidentiality. So I can't now tell everybody about confidentiality. So then and he was saying that because, hey, I was his attorney from 2015. Now, generally that would cover you in most minor matters, but then the judge said, well, no. It's not about just confidentiality, because now you're testifying. So now we're talking about privilege. Is it privileged? And that's where the confusion comes in, because even Terrence Bradley's attorney kept screaming 1.6 confidential. And he was like, well, no, it's not confidential. So now we're talking about attorney-client privilege. what Joe said is exactly correct. What Fannie Willis and Nathan Wade are trying to do is say anything Terrence Bradley told them is attorney-client privilege over those 5 and 6 years, which is BS. Everyone knows that's BS. But I do think if they can make a showing that the information Terrence Bradley did give to Trump's team was privileged, that's a problem for the whole thing. But I also agree you can make an argument that it's not. And the argument I will say, reason why I would say they should be disqualified is because the issue around the privilege, which I believe has been met, and why privilege shouldn't really even apply here, is that the principal, Nathan Wade, has already testified to the information. He's already said the relationship started 2022. So now his attorney can't sit there, and if he knows that he's perjured himself, can't sit there and use privilege as a shield to cover up the perjury. And so now when I ask him, well, listen, what did your client tell you about this particular issue? Then it doesn't make any sense for for him to say it's privilege. It can't be privilege because he's just testified to it. Literally, he's waived the privilege by testifying it to an open court.
It's a powerful
Does that make
argument.
sense?
That's a great point. And just to explain that the difference between 1.6 is that Nate was going on about and correctly is that there's it sounds very similar to most lay people probably when you talk about confidence versus privilege, but the distinction in law is very significant because privilege would protect him from testifying in court. Confidence is completely blown away by the court because confidence means in general you're not allowed to talk about it, but if you're hailed into court via a subpoena, you must talk about it. And that's why saying 1.6 in this setting, in a court setting, doesn't mean anything. The judge is like, who cares? I don't care.
Well, no,
this is a courtroom.
No,
Yeah, go ahead.
The judge could have ordered him to testify, and it wouldn't have been. It would have bypassed that rule, but he couldn't order him to break privilege. So
yeah, you cannot order him precisely. You can't order him to ignore privilege, but you can order him to ignore confidence. So when the guy is screaming 1.6, judge's like, well, I'm telling him to testify, so forget your 1.6.
Yeah, I thought they had the in-camera review Friday afternoon. I thought Terrence Bradley would have been out of the country by Monday morning.
How do you determine privilege without revealing what's discussed? It sounds like a dumb question.
Well,
but
that's what an in-camera review is. He's going to reveal the privileged information to the judge, and then the judge determines whether he can use it in his own mind to make the determination. But the issue here is that the information, to be honest with you, is really not even privileged at all, because soon as the principal testifies to the information, then there's no. Then what privilege is?
What are you hiding? You already put it out
in open court. So the only thing that you could be protecting under generally the crime fraud exception is perjury, right? If he's testified to something that he's told you that's something different, then the only thing you're doing now, the privilege is protecting perjury, which can't happen because that's essentially the crime fraud exception. So the argument that I think Trump's team should be making is that, number one, the privilege doesn't exist because he's already testified to it, and two, even if it's something different, if the attorney is telling you something different, then guess what? That's perjury, and now you're in the crime fraud exception where he's now facilitating a crime. And number three, I won't even say it, is that the attorney was the one who filed the interrogatories in which the perjury was there. So if he knew it was perjury, if he knew it was false, he filed the damn documents, and now the guy's testified to falsely. The number one, I think the attorney, Terrence Bradley, he's probably going to be disbarred. Filing false documents, perjury, and the whole and giving up
potentially SA also.
Yeah, it's like he's gone. He's gone. So I honestly don't think the privilege even exists here, and I think we're waiting for the judge to say that. But that's why I think the whole privilege argument is really a non-starter because of all those particular issues. But
question: if I'm just curious, as attorneys, if your client is perjuring himself or something, and you know it, is it your duty to reveal that, or what is your responsibility?
In Canada, you're not allowed facilitating or in continuing. But if you're examining your own client and they start lying, you can't pursue questions if you know they're lying, but you don't have an obligation to out your own client.
Right?
Is that the same in the States?
That I would agree with that. I think that you're prohibited from publicly revealing that he's committing a crime, but I don't think you certainly are not allowed to help him perpetuate the crime, and that would be my initial take on it. That's exactly the sort of question you ask in a bar. You call someone in the bar, and you're like, all right, I got to know what my responsibility is here, because because this is something a lot of people may not realize, that most attorneys, especially in litigation, but I think even outside of that context,
You gotta call them, yeah.
we are frequently calling the ethics committee, if only as a CYA, because sometimes we'll just see your bar association will have a hotline that's available to you, which will basically, you call that up and there'll be different rotations of attorneys who are assigned to it, where you're like, okay, I have this potential ethical conflict and I don't know what my responsibilities are. I even did it as a streamer. When I was streaming the Colorado hearing about Trump, and the judge looks into the camera and says, "You're not allowed to restream this." And so I actually called the New York Ethics Committee, and I was like, "I don't believe that has any bearing on me because she has no jurisdiction over me. I just want to confirm this." And this way, in case she was talking to me, which at a certain point, at first I thought she was, turned out she was something about some other streamer, but that she was talking about me, and then Colorado wants to come to New York and complain about what I'm doing. And the very least, I can say, look, here's the date and time when I called this person from the ethics committee, and this was their name, and this is what they told me. So I can't be punished by the New York bar. The New York bar is far less likely to punish me.
So it's a defense, a preemptive defense.
And it's also to give you guidance. The idea is that you should they'll tell you what you're allowed to do, what you're not allowed to do. So this way, you sort of are walking, you feel like you're getting a second opinion from someone who's supposed to be an expert, who's walking you through what the law is. And so it's a defense in the sense that as long as you follow what they tell you, in that case,
right. If they told you don't do it and you did it anyway, then it wouldn't be a defense. But they said,
if anything, they'll smack you in the face for it, right? That you knew it was wrong, you were told it was wrong, you still kept doing it.
But one thing I want to make very, very clear, though, in this case, the lawyer prepared documents and submitted them to the court that he knew was false. Because remember, Nathan Wade testified. Wrote interrogatories that the relationship started in 2022. His lawyer knew that information was false. Now, as an attorney, if I cannot present filed papers with the court that I know are false, that's allegedly what happened in that case.
I'm gonna look so smart when this actually happens, because I called it before that Nathan Wade was using Terrence Bradley as a lawyer, like in name only, just so he could draft his own pleadings and then use Nathan Wade's letterhead. I'm convinced Bradley's going to say at some point, look, this is what happened. He drafted all the proceedings. I didn't verify them. I may have signed off on it, but I wasn't perjuring anybody, because he wrote them basically, and he'll still get in trouble. But he's going to throw Nathan Wade under the bus sooner than later.
Well, Fonnie has too. What was it she said about him? What was it? 1 minute she talked about how he was the most honorable, best person in the world, and then she called him a complete misogynistic, bad.
Can you believe what they did?
You remember that?
And I'm so happy that's what their comeuppance is coming from. That they were everyone who missed his testimony. You may have missed the fact that he got up there on the stand and his attorney kept invoking it. And when the defense, meaning Trump and all the defendants were questioning him, he kept bringing up privilege.
Protecting Nate up the
was
wazoo.
protecting him, so thoroughly protecting him. It was hard to find anything that it really helped the defense. And yet, for one reason or another, the defense counsel, Abby Cross, then does cross-examination. And she decides to humiliate the F out of him. And the way she does that is that she starts drilling him and about why he left the firm. Now, when he's answering on direct, he's like, I can't talk about it. It's privileged. I can't talk about why I left the firm. And they're like, you can't talk about why you left the firm? It's privileged? And he's like, yeah, it's all privileged. I can't talk about it. Then he starts getting drilled by Abby Cross. He's like, who's Anna Rodriguez? Isn't it true that people saw you and there was all these complaints against you for SA?
That he paid her $20,000.
And you gave $20,000 to pay off and has hush money to pay her off and silence her. And isn't that true? And basically, and saying that's why you left the firm. You left the firm because of that. All of a sudden now, she starts saying that, and the judge is like, why are you asking him? How is this relevant to anything? And she's like, it goes to show bias against Wade, which I don't know how the hell that would even show bias against Wade. But here's the thing. Now, when he starts admitting it, the judge is like, wait a second, you said 10 minutes ago that was privileged, and that's definitely not privileged. Yeah. Now I'm questioning whether you understand privilege. Because of this cross-examination, I basically don't believe that Bradley knows what privilege is, where it attaches, what the hell, and he just says privilege all the time. Now I need to go back and look at all the times he said privilege 2 hours ago and start looking into whether or not that's privilege. The only reason that this in-camera review, which may lead to Fannie Willis and or Nathan Wade to be suspended or disbarred is because Abby Cross, on behalf of Fannie Willis and the state, was trying to embarrass him that he's a lecherous jerk, and that's why their careers may be destroyed. And to me, I love that.
No, but Terrence Bradley's lawyer gets up and says, "Well, this is opening the door to this is opening the door." What did he say? This is opening the door to challenge privilege, and then the lawyer for Trump is like, "Yeah, that's where I was going with this."
Yeah,
it was wild. But they did it to destroy him because he had the audacity of talking to and ostensibly helping Trump's attorneys.
He was giving up the privileged information, right? If number one, he violated Rule 1.6 for sure. Because he's literally giving away confidential
when
stuff.
he texted Ashley Merchant that information, he's breaching his confidence. If not,
unless he knew that he only knew it as Nathan Wade's friend, because Nathan Wade came in and bragged about boning Fannie.
But I'll tell you the reason why that. But then he admits on the stand that the stuff he texted her was privileged.
Well, he didn't admit it because I think he's lying about it. No, I know.
You may say he's lying about it, but
I'm saying he's lying about it to protect Wade. And then how do they thank him? By sticking a red hot poker up his butt.
so either he was lying about it being privileged, which then gets him disbarred. Even if it was privileged, it gets him disbarred. He's got he's literally
sunlight is the best disinfectant.
No,
where you go with this?
In my mind, there's no question he was lying about it being privileged, confidence, whatever, because he knew it because they were buddies. They talked about it. They bragged about it. They worked together. They would go out for lunch together. He lied about it being privileged or in confidence to protect Wade, and they still decided to destroy him. And in so doing, basically, undermine every other time he invoked privilege or confidence.
Well, I'm thinking they destroyed him is because they wanted to show two things. Number one, the reason why that whole sex scandal came up was because they wanted to show that Nathan Wade kicked him out of the law firm because of the sex scandal. He was grabbing him. So that was what they were trying to get there. And then I think they're trying to show that he's a liar to destroy his credibility. So because they know for a fact he's probably going to say, as he did say in those text messages, the relationship started before 2022. So that destroys his credibility, because don't forget, even if they win on the privilege, you still have two now witnesses who said the relationship started earlier. The first woman, they said that they tried to destroy her credibility, saying that she was fired from the DA's office and she's got an axe to grind. And now they're saying that he's got an axe to grind because he was fired from the law offices because of this, now he's the snitch who was giving up all the information. So that's how they're trying. So it's a smart tactic by Fannie's attorneys to try to say we're going to destroy their credibility just in case they get the information.
Yeah. I wouldn't attribute much intelligent strategy to the way they handled it.
Well, no, what Anna Cross did,
what you got, right? You can only deal with what you got.
What Anna Cross did from a mob perspective, like a gangster perspective, makes sense. Like you're going to go kill Corleone because he betrayed you. From a strategic perspective, it makes absolutely no sense. And I don't know if she's taken flack for having done it.
That was just incompetent. And you know what? Perhaps sometimes we as attorneys lose sight of. You sort of see your eye on the prize as somewhere that you can feel like you can get a win, and don't actually process in your brain as to whether that's actually helping the cause or potentially making it explode in your face.
It looked like they had a strategy that didn't factor into how well it went in terms of protecting Wade. Like they had planned to destroy him because they thought it was going to come out. They needed to destroy his credibility. It didn't go that way during the hearing. And then they stuck to the original strategy to destroy him anyhow, even though in so destroying him, they destroyed their own defenses.
But don't forget, though, he was the one because the whole motion was from him. So if you want to attack the motion, what better than to attack the source of the information? So that was my thinking of why they were attacking him, because again, he was the one that fed them all this information. Remember, she even sent him the disqualification paperwork before they filed it, right? To make sure this is all correct. Are you sure this is all good? So
it looks good.
So what? So again, it's like the mob, right? Dead men tell no tales. You try to kill him.
Do you think just like the mob, always in what is it?
Never in writing, always in cash.
Never in cash.
Do you think Terrence Bradley would come on my channel for an interview if I could reach him?
To testify to what?
No, just to talk, man. I just want to know how he's feeling.
What's he gonna say? Well, he's already given a privilege of confidentiality, so he doesn't really care anymore. Right?
Oh man.
Well, the dude worked for cheap, by the way. If I recall in his testimony, he was getting $60 an hour to split 3 ways.
65.
Well,
65. Well, come on now.
But Jeff, but you know what? The way that works in a law firm, though, you have the grunts do that, so you pay. He's not doing that for 60.
No, they got a paralegal,
and they're the ones who are doing that, and you just collect that.
Viva, you got to frame it as him telling his truth. That's how you got to do it. Frame it as you got let the world know your truth.
Now I frame it as you just got publicly executed. Here's your payback. Come, let's talk. We're not adversaries anymore.
Oh
man.
All right. Danny had a question here. Any of you guys covering the Alabama IVF case? Mm-hmm. I know very little about it.
Not at all, but I think we'll probably talk about it Sunday. That's where they recognize the IVF eggs, not implanted as humans or as
in other
protected.
words, they're saying embryos are people, so they're giving them rights.
Well, it's an interesting thing. I mean, I'm not sure that I mean, to set aside all personal beliefs. I didn't appreciate how ugly that industry could be until the guy, who was it, Mr. Beast's former show partner guy. The idea that you do fertilize all of these, and then when they discard them, I've never actually thought about what it means to discard.
Oh, yeah, that they
fertilize.
They reduce. They call it reducing in the pregnancy, which is really.
What do they do? Oh,
they destroy them. I mean, they destroy them. Now,
essentially, they put in a bunch of them, and then they're starting to take. How many do you really want? Oh, twins only? Okay.
Yeah, only certain features, and then they discard the others. Where I would think there'd still be a market for those. Like there are people who don't want to pay the money for in vitro fertilization, who could reuse what would otherwise become a human inside the uterus. But I never even stopped to think about what it means. You have you need to make more than what you need because they don't all necessarily take, and then once they take, what do you do with the excess? Interesting.
Yeah, I've always thought that the reduction is dark. Okay, let's flip a coin. Okay, well, you two are okay. Or just.
Oh, it's not flipping a coin. They're looking for straight up preferential traits. And I wonder if that's just sex more often than
hold on. Breaking news, Atlanta Constitution Journal. Judges set March 1st hearing date on disqualification.
Ooh.
So next week, Friday.
But so that
all this new information is coming out. So with
they're going to bring
all that stuff. Yeah.
They're going to bring back
Monday. Wait, hold on a second. That's a continuation of the hearing?
Yeah, so remember they had the in-camera review, and now they have those new
that's
stuff
when closing
out,
arguments are going to be a week from today.
No,
I'll
does it say
closing?
Closing or new or more?
Or is that a new thing? That's exactly my question.
This is the extension of the. They're hearing that the last one. Yeah. So in other words, he thought he could rule on it today, but now he's going to have them come back and argue. Looks like he's going to have them come back.
More evidence, not summation arguments.
And this is what I speculate that in the wake of Wade's motion, that the judge is likely to ask Trump and the defendants to all put in opposition to his motion to withhold the in-camera review. This is what I would have thought would happen, is that the judge would say, hey, dude, I want, defendants, I want you all to put in opposition to his motion if you have any. And that way I'll make a determination on having the in-camera review and give them a very short deadline to put in their opposition to his motion. And I don't think that motion is going to fly at all. I think that motion is.
We are seeing the text messages. If we're going to predict that now with this new information, we're going to see some of Bradley's text messages. It's going to confirm, without a doubt, that Nathan Wade and Fannie Willis lied about the date of their sexual relationship. They're going to get disqualified. They're going to get disbarred. But then we've got to deal with the other 15 Trump trials.
That's if you believe his credibility over their credibility.
No, but Nate, there's no question. There's actual evidence. There'll be text messages between Wade and Bradley, emails. There's no question. The whole thing is like that there would be no material evidence confirming the date of their relationship. It's so implausible.
Let's assume they get knocked off. What happens to these cases?
Let's just say removed. No one takes that out of context.
Fair enough. Let's say they get whacked off, and let's assume even the entire because they said that the entire district attorney's office is considered like her firm, and that if she is removed, in that case, let's say the Fulton County entire
the attorney general, Joe.
So that's my question.
No, I think they go to
procedurally, what happens to this case?
Another county, right?
Yeah, so generally with disqualifications, it depends on who's being disqualified. So you could have a prosecutor, you could have an inline prosecutor, somebody under Fannie Willis, be disqualified, and it can go to someone else in the office. But the ability to prosecute anyone in that county is only reserved for one person, Fannie Willis. She's the elected, she represents the people. So if she's disqualified, then that whole entire office is
Mhm.
disqualified because no one in that office has authority to prosecute cases
So
without
what
her.
happens? So what happens?
So
to this
then
case?
what they do is they'll move the case to another prosecutor, either in adjacent county, something like Cobb County, something like that. This happened before where they'll say, okay, you now evaluate this case and determine whether it has any merits. But now if you send it to, let's say, a Republican DA, I'm assuming he's going to look at this case a lot differently.
County? Who decides which?
Generally,
county?
the judge would decide what county. Like it happened. Like remember in the Amadou Diallo trial here in New York, where the cops showed that everybody in the Bronx, because that trial was going to happen in the Bronx, and they showed that there was everybody in the Bronx already had their minds that the cops should be guilty. So they transferred it to Albany because when they did the survey in Albany, they said, hey, nobody up here really knows this case, so they can get a fair trial in Albany. So that's the way they generally do it.
What they're going to do
to another DA's office.
They're going to go give it to Barnes, and he's going to say, "Oh no, didn't I tell you the reason why I turned it down was because it was a bullshit prosecution in the first place? Oh no, sorry, it was because it didn't pay enough, and I had mouths to feed." They should give it to a Democrat from another county, whatever. No one's going to pursue those charges, and there's a reason why Barnes. Oh, I'd love to really understand.
But to be fair, though, generally they'll give it to somebody close. And the reason why is because you don't want witnesses traveling across the state, or so you'll try to give it to somebody in an adjacent county, and you get some bleed over.
I think the point they can give it to anybody else, nobody else would take it. The reason why Barnes didn't take that case, not Robert Barnes, but Governor Barnes,
Roy Barnes,
was not because it didn't pay enough and he had mouths to feed. It's because he didn't want to ruin his reputation pursuing an absolute bogus RICO case against these guys. But
I think the money. Look, let's face it. The money, the hourly on it, I'm sure is well below Roy Barnes' normal hourly rates.
Oh yeah,
$250 an hour is a paltry sum for an experienced attorney. That's an embarrassing number to accept unless you have political aspirations. It's a ridiculously low.
Those are government rates, though. Yeah.
Let me see if I can find Roy Barnes' hourly rate. It is probably closer to 700, maybe to.
I would assume
he's a former governor. I would hope he'd have a good rate.
Yeah, I would assume it's close to
1,000.
It's very close to it. I would say 4 digits. Yeah.
Now, speaking
it's Atlanta.
of,
it's Georgia. It's not New York. So we might be thinking from a different yardstick.
But he's still a former governor. I mean, that does factor.
As far as hourly rates, I don't know if people even realize just how astonishing some of these rates are. I met an attorney who said that his hourly rate is $2,000. $2,000.
But it's also
a couple of people like that.
It's math at the end of the game. You can charge $2,000. First of all, some people think by charging a lot, it'll give them esteem, and people will think that
he was active. He was an active attorney. Yeah. He was an active. I actually met him in court in DC Circuit Court. Not DC in DC trial court in the Perryman courthouse in DC, and he was scouting out judges and how they were handling J6 defendants because he is representing some of the premier J6 defendants. So he's not just someone who says his hourly is 2,000. I'll tell you right now, my hourly is 1,500. I can say that. I've never had a client pay me 1,500, but but if someone wanted me to hire me now, that's what I would say. I don't want your freaking case, and I'll charge you 1,500 an hour. And I would say it's not worth it. Don't do it. But if you want me that bad, yeah, 1,500 an hour, I'm all yours. So, yeah, the point is though, he is getting it, and people do get it. And a former governor. Yeah.
Especially if you're talking about plaintiff attorney versus defense attorneys and all that type of stuff too.
Ron Coleman wants in, Eric.
Yeah, sure.
Ron Coleman gets 2,000.
And not that I'm selling my upcoming show at 2:30. I'm going live at 2:30, and
I don't know his rates.
Then we have our locals exclusive.
Ron Coleman's worth 2,000 an hour.
Oh yeah, for sure.
I know tax attorneys. I know tax attorneys in Canada easily charge 1,000, 1,200 an hour, and typically it's value added, and you can see the fruits of that investment. Litigation, man, you're just setting money on fire.
Yeah.
$33 a minute, says Deadfish. Speaking of crooked judges, Nate, Joe, you're both. Oh no, Nate's not in New York anymore. What the hell's? What do you make of what's going on in New York?
They just overturned the non-citizen voting. So, is that what you're talking about?
No, I was going with Engeron and not staying his $455 million judgment pending appeal, giving him another 30 days.
But that happened. That happened with Amber Heard. Most times you get judgments, they'll ask for the stay-in. That's a normal thing.
Yeah, I have a lot of thoughts about this judgment execution. I know Letitia wants to take the
buildings.
And I think that there's a lot of legal problems, which they likely will get help from Judge Engoron when it comes to executing his judgment. It's certainly the first person it would come back to is Engoron, and he's obviously very sympathetic to the state in everything regarding this particular judgment. So I would anticipate that he will try to help them expedite jumping through hurdles. But there are real issues with trying to go after the building, because what you need to understand about the way real estate works when you're talking about people who are competent.
I do that today.
Well, I asked you.
Hey, Ron, put yourself on mute.
Mute yourself, Ron.
Ron, we hear everything.
Yeah. So that you have to realize that every real estate in every mogul, and not moguls, even like junior real estate, like entrepreneurs, they take their property as an asset and put it into a shell company. And they usually will call that company, even to make it simpler so they don't get confused by coming up with a new original name, they'll call it by the address of the property.
Sure.
So there's almost certainly a company out there that's called 40 Wall Street LLC, which is some 40 Wall Street Holdings, something like that, Inc. And they'll make some corporate entity, and the only thing that entity does is that it owns. It's the owner of record of that property. So now, and then when he buys another building or another house, even Mar-a-Lago, I'm sure, whatever the address of Mar-a-Lago, they may call it Mar-a-Lago LLC, but whatever it is, that's a different company. Now, when you get a judgment against Trump, the individual, that company can be owned by another company, another company, another company, and you can say that ad infinitum. There can be literally no end to how many companies they are. And some of these companies may hold more than one of them and be like an umbrella of 2 or 3 companies. And each of these is a corporate veil that must be pierced, and you have to go through due process.
No, but Joe, I think
to pierce these corporate veils.
I think the judgment just assume that the judgment applies to all of the corporate entities that own the assets. Set aside the piercing of the corporate veil argument. The issue I have is so they've asked Engoron to stay. I think it was for 30 days execution of the decision, so they could weigh their options. He says no. Or do they go get an injunction at the Court of Appeal to stay execution pending appeal? Where would they go to get that particular order?
They're unlikely to get that. They could appeal. They could appeal his rejection. They probably should be making a formal application in court. I'm not sure if they have made a formal application in court to get a stay. But if they're appealing the decision anyway, right? So they can go to the appellate court and ask for the injunction on the basis of the appeal. Normally what the court will do is they'll try to estimate, all right, how much of this judgment they'll say you have to put in on a bond on the entire amount. But when you're talking about a ginormous amount like this, they'll probably say, what is a likely reasonable estimate as to what a judgment creditor could execute during the time that this is an appeal, that now they are being forestalled from collecting those monies. So if they estimate that during the next year that this appeal is going on, they have a reasonable chance of collecting $40 million. So what you need to do is they'll tell a judgment debtor, you need to get a $40 million bond. You can go to a bonding company, you can take $40 million and deposit it with the court, and that'll be like the court holds on to that money, which might be the right move in this case because you're talking about such vast numbers. You don't want some private entity to run off with your $40 million. And also the bonding company would charge a fee of like 10% or something like that, and you'll never see that portion of their fee back. So then once you satisfy that now they're not being hurt by this stay, so you can basically have a stay and they wouldn't be able to do anything.
But that's my issue. Like Engoron's not gonna ever recognize that. You're not dealing with liquid, fungible assets that can be hidden. You're dealing with real estate that's not going anywhere. There's zero prejudice to not staying the order, and there's total prejudice to compelling payment of $500 million pending an appeal.
It's not zero prejudice to them. If you're sitting here it's not zero prejudice to this thing.
Other than the interest. So let's just say that
it's not other
9%
than the interest. And the interest rate that New York has is very high. It's 9%. Yeah. It's one of the highest in the country.
It's a fucking joke. I'm sorry.
It's one of the high. And trust me, I very much enjoyed that 9% interest rate for a while. It was awesome when I was in judgment execution.
Okay. But now the memes are going to start.
Joe. Oh yeah,
literally rubbing your hands.
You have to. You have to lean into it. You have to lean into it. I'm telling you, Viva, this is how you'll deal with it. Lean into it, Viva. Lean into it. But Yeah, no, it is really high, but people don't realize that 7 out of 10 judgments no one ever collects a dime on because it's so hard to execute a judgment. I don't mean get full satisfaction. I mean literally you have $1 million judgment that you can't collect $1 on. That's on 7 out of 10 judgments. Then the reason is because there are so many ways to shield yourself. First of all, being a resident of Florida, the primary, from what I understand about Florida execution that I never really tried getting into at all, is that if you're the primary provider, you can't garnish any wages from that person. So potentially, I guess you can seize assets, but you can't seize the homestead of the person, the primary residence of that person
too.
Yeah,
Texas
and Florida. Texas and Florida are the two most difficult states in the country to execute a judgment. It's impossible to execute a judgment there. Now he has assets here in New York, and that's certainly what they're going to be looking to attach. And in theory, let's say you were right, Viva, and that they managed somehow to attach these buildings. Because they have a judgment against it's in the name of Trump organization, which I'm positive it's not. No, or it's in his personal name, which I'm positive it's not. But let's say they managed to pierce the corporate veil and they get that judgment against the entity that holds that property. So could they turn over the building? Look, you're talking about a massive judgment here. Normally, what they would say is you can take the assets that are coming into it, which would be the rent and revenue. When you're talking about a normal size judgment, that they could be collecting that. Turning over a building from one entity to another is another procedural step that you would have to go through. That is more easily expedited by a court once you have a judgment against the entity that holds it. It's much easier to do that than it would be to actually get that judgment entered against the party that holds the property. And I'd be shocked. I'd be shocked if they're named. Anyway, I feel like I'm boring people talking about this.
I feel that there's active discrimination here, Eric. This is like Hollywood Squares, but I can't say it.
Well, I don't know.
I
What
just
do you
thought
mean?
we were playing musical chairs.
Well, first of all, it looks like since we started, Donnie's gotten arrested, and Ron Coleman was having the most interesting conversation ever that we all actually wanted to hear.
Yeah, what happened? Is everything okay there with
We're making an offer. It was foolish of me to think that you'll explain after what an offer is after I bail out, which is now.
Okay.
Aren't you? And you yeah, I'm sorry, guys.
The wife is like, "What were you thinking, even getting on there?"
Yeah, we got
those
got
degenerates.
1,000 people coming to our house in about 10 minutes.
I'm so sad I'm going to miss it. I'm so sad I'm going to miss it. I'm so sad I'm going to miss it. But I have to go to my my future son-in-law's offer. So
right, you're going.
I'm going to Staten Island.
That's right. You explain it, guys.
Take care, Ron.
I regret darkening your door.
Good seeing you, brother. Mazel.
Yiddish means calling up. It's the Jewish custom of a groom being called up at the synagogue for an aliyah, the recitation of a blessing over the Torah. I'm joking, people. Okay, so who's getting married? Is Ron's kid getting married?
Yeah, so whoever the groom is, his side of the family, on the Sabbath before the wedding, will have what's called an afruf, and the entire family basically will, even out of state, they'll come in for the entire Shabbos and spend Shabbos there. So the parents of the groom, which in this case is Ron, end up basically spending thousands of dollars on catering meals for them throughout Shabbos for potentially 70, 90, 120 people. You need to find a venue which is able to house all of them. I did this for my son back in September, and he's dealing with that now. My daughter is getting married on Sunday, and I'm going to my future son-in-law's offer. I'm now the traveler because I'm going to the groom's house because it's customary for at least the father of the bride to show up to the offer. So that's where I'm headed. As soon as I wrap up here,
coming in.
I did my 24-hour live stream at the end of January. That's why I did that, to raise money so that I have the money to pay for this wedding on Sunday. So.
Oh, fantastic. Danny, I think you were jumping back in. Are you going to tell us about that case in Alabama?
Yeah, if it's all right. I'm not going to get too excited about this. All I'm going to say is that I think that the Supreme Court ruled very, very broadly based on Alabama statute. And I think they stretched the definition of what is encompassed by the death of a minor child to really absurd lengths, in my personal opinion. I think that they were trying to fit their own narrative. I don't think it checks out legally speaking, and I think that it's a bad move. It's bad, especially for couples who are going for IVF, because one of the issues here is that with IVF, by nature, you have to somewhat choose which embryos you're going to keep and which ones you aren't going to keep. Keep in mind, each cycle, when a woman has a cycle and they go through the process of extracting the ovum, once they get all of the eggs, there's probably potentially between like 18 to 25 eggs. Out of that, once they are fertilized, there's an even smaller amount that are viable, that are replicating, that are able to be inserted into the uterus. And whether or not the uterus actually is implanting these embryos is where it gets tricky. So typically speaking, you'll have like 4 to 5 different embryos implanted at one time, with the expectation that the human body is not going to accept and they are not going to implant. As a matter of fact, most women get pregnant. It's a 50-50 chance. It really is a 50-50 chance on average, whether or not the body takes the embryos and they implant.
Is that why you have all the cases of like sextuplets on one female and then otherwise because they all took or whatever?
Correct. Sometimes they'll all take, sometimes only a few will take. It depends on the provider who you're working with and on the person, particularly. Some uteruses are open to having multiple implantations, some are not. And so one of the things that the patients need to decide before the embryos are actually implanted, or there's an attempt to, is which embryos are you going to implant? Do you implant all of them? Do you save all of them? If you destroy some of them, part of the process is identifying which ones are more likely to survive in the womb and actually being implanted into the uterus. Because let's say that you're a woman who is not likely to take multiple embryos, okay, based on prior cycles that you've already done with your provider. If that's the case and the provider knows this, what they don't want to do is take one of the less likely to survive embryos. So they may be alive in the petri dish, okay, and they may be replicating in the petri dish, but for some genetic reason, the provider understands that that embryo will not survive once it's implanted or once there's an attempt to implant. If that embryo does implant, though, and the body is likely to only take one embryo and not to allow any other embryos to implant, then you basically have a miscarriage, and it's a complete waste of time and money and expense and heartache and physical work that goes into the process of completing an IVF and having it be successful. So that all being said, the destruction of embryos is inherent in the process of IVF. Now, my understanding is that some countries, they limit IVF implantation. They limit the number of embryos that you can create. So let's say you create one embryo at a time. If it's viable, then you go ahead and freeze that with the anticipation of implantation later. The problem, though, is that, like I said, it's very costly to do this process, and it's very physically taxing. So when they go to harvest ovum, let's say they harvest like 18, 25 ovum, and they go and harvest, a ton of sperm. If something happens to the ovum or to the sperm, they have to go and reharvest or get another sample. Well, this is a huge problem because there's a dearth in sperm, viable sperm, worldwide. We've seen a 16% decline in the rate of viable sperm, and this is happening to men worldwide. This is a serious problem. And why I bring that up is because men are wanting to get on testosterone. We have, young children who are being introduced to hormones that they should not be introduced to at that age, that is messing with their fertility. And so what I'm saying is that if we go to the one embryo at a time standard that some countries have adopted, there is a risk that if you have a man who's coming in who's infertile, and by the use of Clomid or FSH or other medications, he's able to increase his sperm count and the sperm count viability. if he's able to do that for a short period of time, enough to provide banks some samples, and those samples go bad, and he goes back on testosterone with the understanding that those samples have now been banked, so it's okay, he can go back on testosterone. Well, now he's screwed, because if something doesn't work out with those samples and they aren't able to create viable embryos again, everybody's screwed over. So for practical reasons, for financial reasons, and for physical reasons, it is impractical to join the consensus that you should only create one embryo at a time and that embryo destruction should be outlawed. But that's essentially what they've basically done, is they've created some civil liability on these providers. If I was providing advice to one of these fertility clinics and they were my client, I would advise them to move states immediately. I would not advise them to continue their practice, because as part of the practice, as I said, embryo destruction is part of that process. The other issue that we have is that the court went way outside of the scope of this individual case. In this case, the appellates, there were 3 couples. 2 of the couples are suing on the basis of wrongful death of a minor child under the statute. That is what the court is looking at when examining this case. One of the couples sued for breach of contract, which is the appropriate lawsuit, and they sued within the statute of limitations. And so they won on those issues, but they were enjoined anyway into this appeal, and I can't exactly remember why. Regardless, they all come up on appeal because as part of the contract with the clinic, they had cryogenically frozen embryos that were available in a what we would consider like a freezer nursery, a cryogenic nursery. Some rando got into the clinic, grabbed these embryos that belonged to these 2 couples, and in the process of grabbing them out of the freezer without protection, he got frostbite, dropped the embryos, and they died. So that is what the lawsuit pertains to, was really the clinic's negligence. And because it was outside of the statute of limitations, they could have hanged their hat on the death of the minor child statute, but the trial court dismissed that claim because they said it doesn't apply to embryos. Now, the logic is, an embryo is a human being. The logic that the court of Alabama used is that a person is a human being, that life begins when sperm meets an egg.
At conception. Yeah.
At conception. And they then use this to say, well, if that's where life begins, then it doesn't matter where the life is housed, whether in the uterus or outside of the uterus, it is still a human being. I disagree with the court on this. You cannot, it is a condition precedent that you must have a female uterus in order to have a life, a human life. If you have someone in a petri dish for 14 days, they are going to naturally expire. Now, if you keep them artificially alive and you continue to grow the fetus, which there's a lot of argument about whether or not that's even possible, but assuming that it is possible and assuming that there are no other restrictions, then it would make sense for the court to hold that life begins, at the point of conception. The problem, though, with this, again, is it makes IVF basically impossible, the process of IVF impossible for them to perform without being in violation of the statute or giving rise to claims that can be brought against them by disappointed parents.
What about the argument of the test tube baby? Because part of the argument was that you don't need a womb to actually have a baby. You could have the peripheral test tube baby. So
an incubator.
Yeah,
that's well, and that is the court's argument. They say, well, this is an ongoing issue. This is going to be an ethical issue, a legal issue to determine at another time. But regardless, we're going to make this decision right here because it's consistent with our holdings in prior cases, in the MAC cases, which I haven't read through. But my issue with this again is, does this apply to test tube babies? And if it does, why the hell aren't they waiting for this test tube baby case to come along? Because this, like I said, the way that they crafted their holding is extremely overbroad, in my opinion. I think they would have been a lot safer to say, yeah, in these certain circumstances where you have these arrangements, this would apply because there was a duty here, and that duty was dropped by the clinic. And so because there was a duty and it resulted in the wrongful death of these, what could have been minor children, I think they should have sent them on their way. It's unfortunate that these couples lost their embryos, but the court, like I said, they could have been much more specific in their holding or just denied them outright. And I think they should have denied them outright under that particular statute. there were other civil statutes that were available to them to utilize.
One thing I can't.
Danny, I think they're calling you.
I know. I'm heading back. I just wanted to pop in and say that and give you guys kind of an overview of that case, because it's really important and it's very heartbreaking to these families. I feel so badly for these poor parents who, have spent tens of thousands of dollars. IVF is not cheap, and every single cycle is expensive. Every single cycle is risky.
Danny, but wouldn't this be, because I'm assuming this is consistent with the life begins at conception, what essentially conservatives have been arguing against Roe v. Wade for years, right? Life begins at life. So this
some
just
conservatives, we're not all in agreement on that. That's the problem.
Because my understanding is that if that's the argument, and if that's the case, then it seems like this would just be a logical extension of that position, right? No matter where the egg is, it's still a person. But so you're saying to qualify it, it would only be if it's actually inside a woman's
correct
womb at the time.
Inside a womb. And I think that that's more legally consistent. I think that's traditionally consistent with jurisprudence. They talk about women who are with child. Even the court admits that within their own research and within the Black Law Dictionary, they're talking about a woman who's with child as being a minor child, to which this statute would apply. So that's my point, is that there's a condition precedent. If you're talking about cells that are replicating on their own, you're talking about essentially, I really like the cake mixture analogy. It was used as a stand-up comedian's, bit, but I think it's really true.
Bill Burr made
Bill Burr.
Mm-hmm.
So you have to have an oven. That's the condition precedent. You can have a baked cake. You can have a cake that is overcooked, but unless you put it in the oven, then it's not a cake. At that point, it's just batter. So that's my position, and I've held that position for a very, very long time as a pro-life advocate. I have issues with this ruling. I think it's inconsistent with jurisprudence. So those are my thoughts. Love you guys. Bye.
The analogy is going to fail when you can
they're test tube babies.
Yeah, well, you can if it ever gets to the level of science where you can grow it without the oven that was the womb.
There are test tube babies. There are test tube.
But they can't.
Obviously, historically, when they're talking about a woman being with child, it's because they couldn't conceive of it outside the womb of a mother, or developing from embryo into fetus and go through all the stages of development outside the womb of a baby. So that's why they're specifically referring the womb of a mother. I don't really see that that's compelling argument, because historically that was the way it had to be done. That's the only way they can conceptualize it happening, that means necessarily that there's no life outside the womb of the mother. I mean, here's an example of life outside the womb of the mother. 1, 2, 3, 4. 4 people here.
No, that's only after having become
after
viable.
Birth. Yeah, after viability.
After viability, not
the
before
viability argument.
Okay, so you're saying viability. So now we're going to reframe
now we're back
it.
To
but it's more specific than viability. Possibility. There is no possibility that an IVF fertilized egg becomes a human.
That's not true, because you could, even if you implant them, right? That 4 of the 5 are going to be so.
But then at least you have possibility. But until they're implanted, there's no possibility. Now, I appreciate that people are going to say it's life, it's human life, nonetheless, with no potential of becoming a human unless it's implanted. But until such times you get different size tubes, and you can have your test tube baby go from the first trimester to the second to viability outside of the tubes.
Hey, I just one quick thing about the Fani Willis thing. Have you guys seen the new filing that the defense attorneys put out?
No, when did that happen?
Does it have Does it have the heat map?
It's with all it's with all the text messages and all that stuff.
Oh,
here. I'll share it right now. Let me do 2 things.
Give me a link.
Put the link in the side chat, because I know you guys are going to want.
I'm talking about it.
Is in the side chat, and then I'll share it so we can all see it together. It's just 8 pages, so it's not big, but yeah, I've been. Because this is what I'm coming out. So the link is in there, and I'm going to present it right now to you guys so everybody can see it.
Now I've got 12 minutes left.
It's damning. It's damning. Yes. I don't know how you get out of this.
I want to see something. Can we access all of the text messages?
We can access it, but it's in. Here's the filing. Let me share this one instead.
Hold on, I can open.
So
it here.
Here is the filing. Yeah, but you can download it.
hold
So
on,
this
I'll do
this
that
this is the filing that they made today, and this is why everything was pushed back. But essentially, this investigator, what he did, he was able to get they did a subpoena to AT&T, and AT&T complied with the subpoena. So they got all of both Fannie Willis's and Nathan Wade's stuff from January 1st, 2021 through 11/30/2021. Now, why is that important? Because Nathan Wade, they said the relationship started in 2022. So this is their telephone communication. They got telephone communications, text messages, and GPSs before that time, before they were there.
Well, and also when he said that he was having prostate cancer, couldn't get it up, and was nervous about germs.
Yes, so this is what people are talking about. Like you say, so they did the PowerPoint presentation, which is not here, but in the PowerPoint presentation, they have him leaving her house at approximately 10:15. Other times leaving at 4 a.m. See, he texts Fanny at 4:20. So these are friends. So he's texting her at 3:28 a.m. They got the GPS location where he's leaving her house at 4 a.m. and all that type of stuff, and arriving at 12. So it's
not good.
Why can't I download the bloody document? I can only get it off this.
Scribd.
Yeah,
you got to have a membership.
At the bottom of the Scribd, you can hit download this PDF.
Yeah, I thought it let me do it without a membership.
She's leaving the towers located near his residence at East Cobb at approximately 12:05 a.m. Now this is before, so this is before there was allegedly he was hired. So traveling directly and arriving at Dogwood at 12. So so they're there all night, leaving the Dogwood address at approximately 4:55 a.m. and traveling to the Atlanta area. So,
especially if both their phones are pinging on the same tower, it's not a good look.
What were they doing? Well, they also got GPS location, which now I got to remember to turn my GPS.
Oh, that's true.
Here we got there's I think it's called a heat map. This is coming from our locals community. It says a heat map analysis. And then it looks hot in the after hours. Heavy concentration after hours, 7 days a week. In the period, so what's it during in 2021 from
January 1st, 2021 to November 30th, 2021. So they got them. This is damning. The text messages, the GPS location.
Can you imagine? It's just corruption to the core. And these are people putting other people behind bars who have been doing it for years. These were judges, administrative judges.
We all know this was BS. As soon as they said always in cash, never on the phone. Like, it was like, come on. Does anybody believe that they weren't Maybe there's some people out there who believe it.
If anybody, I can probably get it. If someone can send me the PDF so I can just scroll it more easily.
Damn, even you can't. Look, this is download now.
No, but dude, every time I say download now, it brings me to log in and create an account.
Right. And once you
okay.
It's paywalled.
Paywall.
But no, but it's never. I recall being able to get Scribd before. Anyway, now I just shut the window. It doesn't matter. Okay, so I got some homework to do, people. I'm gonna duck out and go.
I'm wrapping up anyway. So.
Okay, I got to go read this. I got to walk the dog, squeeze a little pee-pee out of Pudgy.
All right, Nate, what do you have coming up?
Well, first we're going to go over this document to show how, unfortunately, Fannie Willis and Nathan Wade, if this is true, they should be disbarred. This is horrible for them. But again, it's something that I've already predicted. They were having a relationship before this. Second, for those of you who are following the what's the case? The super mayor case.
Oh yeah.
So
Tiffany.
I have
Tiffany Henyard.
Yeah, Tiffany Henyard. It's blowing up. It's a bomb. It's everywhere. So the trustees who are in the battle with them are coming on the channel, and we're doing a joint interview. So I have all the people who are against her, the lead trustees and all that stuff. They're going to be coming on the channel and giving an in-depth interview about what happened, why they're investigating, what the FBI has come and seized documents. So that's going crazy. So if you guys want to see that, that'll be next week Friday, and I'll be doing that with actual Justice Warriors. So it'll be me and him. We'll be interviewing the trustees on the channel, and they're going to be giving us the insight on
that's amazing.
That. Yeah, and we have some other stuff coming up too. There's a couple other things coming up, but those are like the two big things. So don't forget, like, share, subscribe. You guys know where to find me.
David.
I'm going live at 2:30, and then we have our locals chat where we're going to interview one of our supporters at about 4 o'clock. So that's going to be interesting because it's seems to be a very interesting personality. But at 2:30, Julian Assange, Fannie Wade, Judge Engoron, probably Justin Trudeau, and a great many other things. Viva Fry on the internet.
All right. And then, as per tradition, we always save Joe for last so he can plug his stuff and give us some words to live by.
Joe Neerman, good logic. I actually right now have a scheduled stream for Monday because that's when they were saying that this thing is resuming, but you're saying nothing's happening with Fannie Willis on Monday. Can I confirm that that's true, that nothing's happening Monday?
Oh, yeah, I would say trust but verify. It says right now March 1st, so that's a trust but verify thing.
So if you see a stream there saying that I'm streaming Fannie Willis on Monday, I'm likely going to change that, but probably not going to be changing that anytime over the next 26 hours. But maybe I'll just make it private. That's probably the quickest way to do it. But yeah, so I'm good logic. I talk about law. I talk about life. I talk about philosophy. We talk about politics, perhaps too much. I stream every night for like 2 hours, but you're not going to really find me when I'm streaming because YouTube won't let you know. So if you want to know where to find me, try goodlogic.locals.com. Goodlogic.locals.com. That's where you'll find where you can access any appearance I can make, like this appearance here. You would have found that I was here if you went to goodlogic.locals.com. That's my thoughts. I'm going to tell you that as far as any other extraneous thoughts, I don't know. I'm all tapped out. The only thing I can fixate on is my daughter's marriage, which is happening on Sunday, and it does actually make me get philosophical. And there's something I did think of that I should probably